Dylan's presentation. I didn't know you were going to put that plug in for Dylan's presentation at Mystic. Do you get a commission for that, Shannon? And more importantly, do I get a commission for that? Hope we do.
I do not, but maybe we should look into that.
Okay. Um, when I mentioned to somebody about a week ago about this presentation, they said, "You must be kidding. They give CLE credits for that?" I said, "Well, I hope so." And that person did say that she was going to sign up. Um, so I think this will be a fun presentation. I know we all go to a lot of CLEs, and many of them are informative. Most of them are, and helpful in our practice. Some of them are rather dry. I had to pick up some CLE credits my last registration period, and I went to one called "Bankruptcy is Not Banal." And I said, yeah, it is. Sort of was banal. It wasn't really interesting, but I got my credit for it. And I went to one about landlord-tenant evictions, and that was rather um, unexciting too. But good work for those people who do that kind of work, and I appreciate that. And I do a little bit of work in both those fields. But at any rate, today's presentation is going to be fun, I hope. This might be the most fun CLE you attend. It will certainly be the most fun CLE I've given. But it also has law implications, and that's why you get a credit for it. Because we're going to talk about Dylan's lyrics and how they've been incorporated into the law, and talk about how his lyrics have affected the law, and maybe to some extent how the law has affected his lyrics. And I'm also going to broaden out and talk about some other well-known musical artists whose works have been incorporated into jurisprudence as well. But let's start with a little bit of data about Dylan, most of which you know about, and we'll take it on the next slide. He was born, as Shannon said, on May 24th, 1941, just celebrated his 85th birthday. His real name was Robert Allen Zimmerman. He was, it's often said he was born in Hibbing. He wasn't. He was born in a hospital in Duluth, but his family was from Hibbing, and he was raised in Hibbing. He was a member of the high school graduation class at Hibbing High School in 1959. That's a picture there of Hibbing High School. Some of you probably attended Hibbing High School, and certainly many of you have been at that school or in its wonderful auditorium. The auditorium there is just a masterpiece for a high school auditorium. It was built during the heyday of the mining era up there, and it's quite a well-known and well equipped auditorium. And Dylan probably performed there in high school musicals or high school plays. Don't know for sure. Can't document that, but maybe someone does know about that. He attended the University of Minnesota for a short period of time after graduating from high school. He was a dropout. Been married twice. He has 6 children. His big breakthrough album was the Times They Are A-Changing, and then Another Side of Bob Dylan. And that was when he went to what was in New York. Some of you who may have seen that movie, A Complete Unknown, with Timothy Chalamet a couple of years ago, did pick up the Dylan story from the time he arrived in New York as a nobody, as a complete unknown, and kind of scrambled around there for a few years until he made his breakthrough in the mid 1960s with those particular albums. There's been a number of movies about Dylan. One of the okay, I don't know if you can see that in the chat box there, but one of our attendees, Scott Bauer, said he did play in the high school auditorium and he was booed. Okay, all right, well, we'll move on. But I guess some of you may have even attended some of his performance, a performance or two. I don't know if you were booing or cheering for him. At any rate, several movies have been made about Dylan. It's kind of an unusual one back in 2007 called "I'm Not Here." And in that movie, there were 6 different actors, including Cate Blanchett, who played Dylan at different phases of Dylan's life. And then, of course, there was the Academy Award nominated, didn't win any awards, A Complete Unknown, starring Timothy Chalamet a couple of years ago. I think it was up for several Academy Award nominations. It did not win any of them, but it was still a well-known movie, and I think it really brought Dylan into. I mean, he was in the mainstream before, but but that movie got a lot of attention, and a lot of younger people who may not have been familiar with Dylan became familiar with him as a result of that movie, as we'll see on the next slide. Dylan has been cited in legal and published legal decisions, let alone unpublished ones and non-precedential ones, more than 200 times. There's more than 200 instances in which Dylan's lyrics have been cited in court decisions, ranging from the United States Supreme Court to trial courts. And we're not going to talk about all 200 of them, but we will talk about a number of them. Dylan has been cited the most of any musician, twice as often as the Beatles, I'm going to talk about a little later, four times as often as the Rolling Stones, who also will be part of this presentation, and more than Bruce Springsteen, Woody Guthrie, Simon and Garfunkel, and other musicians. He's the top performer in terms of music, in terms of his lyrics being cited by courts. So we'll start at the top with a decision by a dissenting decision by Chief Justice Roberts in a case, Sprint Communications Company versus APCC Services, Inc. This is the first time that Dylan was cited or quoted in a Supreme Court decision. It was a rather mundane debt collection case in which there was an assignee of the debt, and the assignee was suing on the debt, and the merits of the case were pretty mundane. But Chief Justice Roberts, dissented from the ruling in favor of the debt collector, and he directed his attention to the issue of standing, which is a pretty big issue with Roberts. Roberts, when there's at least marginal issue of standing, he's very quick to raise the standing issue at oral argument, and oftentimes in his opinions, either for the majority or concurring or dissenting, Roberts is kind of the standing jurist on the Supreme Court, and that's an issue that often attracts his attention. It did in this case. Roberts felt that because of the way the assignment was handled in this case, the plaintiff, had no standing. And in doing that, he remarked that we have to really enforce our standing requirements pretty rigorously, because if we don't enforce our standing requirements, there's going to be a potential floodgate of litigation, and people will be suing who may not have a stake in the outcome of the case. And we want to avoid that. We want to make sure that people who are suing do have proper standing, because if you don't, people are just going to figure, well, I can sue, and even if I don't have standing. And that's when he quoted Dylan's lyrics from Like a Rolling Stone. Robert said, well, if you don't have standing, when you got nothing you want, you got nothing to lose. And that remark was directed to the notion of tightening up standing rules so interlopers don't get involved in litigation when they have nothing to lose and don't have any stake in the litigation. A Dylan quote was used to emphasize that point. Justice Antonin Scalia also referenced Dylan in a decision in Quant versus City of Ontario a couple of years later. Scalia, as many people know, was, I don't know if he was a Dylan fan, but he was certainly the foremost opera fan on the court, and he spoke glowingly about his love of opera on the court. He mentioned it from time to time, and off the court, he was well known as an opera buff. The other opera buff on the Supreme Court who served with him was Justice Ruth Bader Ginsburg, and she and Scalia were usually on opposite sides of decisions, but nonetheless, they were friends, at least as far as going to the opera together. And it's recounted many times how they attended the opera together every year. On New Year's Eve, Justice Ginsburg and her husband and Justice Scalia and his wife would have a dinner together every year on New Year's Eve, and then they would go to an opera. And so they were opera buddies off the court, but ideological antagonists on the court. Scalia did refer to Dylan in the Quant case. The Quant case concerned a requirements of the City of Ontario in Southern California, outside of Los Angeles, that required all police officers to maintain electronic pager devices all the time, on duty and off duty. Pagers were in use back then. They probably still are, but they were much more commonly used back in that many years ago to summon people to emergencies, doctors and law enforcement people. And the city required the officers to have a pager with them at all times in case of an emergency. The officers' union objected to that, and they said, well, this has to be negotiated as the terms and conditions of employment. So this was really, in many ways, a labor law case. The issue was whether the city was required to negotiate with the union as part of the collective bargaining process over a requirement that its officers maintain 24-hour pager service. The union said it shouldn't, or at least the union said we should at least be able to negotiate on it. The city can't impose that requirement without negotiating with the union. And the court ruled in favor of the city. They said this is a management prerogative. There's no requirement that the city negotiate with the union on this obligation to maintain 24-hour pager service. So the union lost the case, the city won the case. Scalia concurred in the decision, but he went off in a little bit different direction. He said, irrespective of the merits of the case, he said he criticized the majority decision for not addressing the issue of the prevalence and omnipresence of electronic devices, which were blossoming at that time. Now it seems like everybody has one all the time, certainly on their cell phones. But at that time, Scalia was saying we ought to examine the issue here of the use of electronic devices in the workplace, how prevalent they are, how pervasive they are, whether they're intrusions on privacy and the like. And he criticized the court for not addressing that issue because he said this is an issue, it's a contemporary issue that we ought to address because, quote, the times they are changing. And that's one of Dylan's breakthrough songs in 1964, quoted by Scalia to call attention to the need to address the issue of electronic devices and surveillance in the workplace. Next slide. Another one of Dylan's songs that made it into the law is a case entitled Los Angeles School District versus, it should be Superior Court. That's a typographical mistake. It's Superior Court in California. That case was a sex abuse case in which the claimant was seeking punitive damages. An employee of the school district had allegedly abused a student, and the lawsuit was brought against the school district for vicarious liability. And the school district maintained that it could not be held liable in the absence of some expert testimony about the school district's relationship to the incident, whether the school district knew or should have known about the abuse that was taking place, and a variety of other issues. So the school district's position is that the claimant's case must be dismissed because of lack of an expert witness to testify in order to impose vicarious liability. And the court there, the California Appellate Court, rejected that and said, no, this is not the kind of case you really need an expert. This is a relatively simple case in terms of determining if the school district's liable or not. There are some legal issues involved here, but judges and juries can figure this out without a need for an expert. And why don't you need an expert? Well, the court said, quote, you don't need a weatherman to know which way the wind blows. That's, of course, a quote from the Dylan Times Are a Changing song. And the court used that to point out that we're able, the court, a judge and a jury can decide these kind of cases without the need for an expert witness under Rule 702. That's the Minnesota rule. This is California, but the rules are pretty similar around the country, that expert witnesses are testimonies admissible if it satisfies certain standards, and the expert witness testimony is based upon some real expertise, not junk science, and it would be based upon education and experience and would be, quote, helpful, unquote, to the trier of fact. In this case, quoting Dylan, they said that an expert witness is needed. And I have a comment here from Scott, who's joining us. I think he's my co-presenter here. Maybe I might have a mistake there, and that's from a different song, but they did quote "Times Are Changing." That "Times Are Changing" motif, Scott, was also cited in another case in Washington, Erickson versus Bartell Drug Company. This case involved the issue of whether employers were required to include contraceptives in a health insurance pharmaceutical plan. Legal issue, as a matter of law, whether an employer was obligated as a matter of law to include coverage for contraceptives in the health insurance pharmaceutical plan. And the court there again quoted Dylan from Dylan's song from "The Times Are Changing," which is from quoted "The Times Are Changing" from Subterranean Blues, right, Scott? To the point that to the fact that society is changing. We think that use of contraceptives is widespread and it ought to be considered part of a pharmaceutical plan in today's society, at least in 2008, because the times they are changing, quoting Dylan. Another case from that same jurisdiction, Washington, concerned the indefinite detention of an undocumented immigrant, an issue that is obviously front and center in today's world. Back then, the issue was whether one particular undocumented immigrant could be held in indefinite detention. More than a decade ago, that issue was addressed by the court, the federal court in the state of Washington, and the court prohibited indefinite detention of an undocumented immigrant. In doing so, the judge in that case lamented the plight of undocumented immigrants placed in indefinite detention by quoting from Dylan's, quote, Chamber of Freedom song and his 1964 album. And the judge referred to the individual in indefinite detention as, quote, the luckless, the abandoned, and the forsaken, a Dylan quote from that Dylan's song. Next slide. And we go on the next slide. A few more Dylan phrases that came into the law. This is a case from Florida, another federal case, Procaps versus Pantheon Inc. This case is an antitrust case involving the production and distribution of pharmaceutical gel caps, another pharmaceutical case. So the issue in this case, this was an antitrust dispute over the distribution and sale of pharmaceutical gel caps, and whether there was infringement by one company as to another company's development of these gel caps. So it was both an antitrust case and it was infused with some infringement issues. The issue before the court in this particular case was discovery and the imposition of sanctions during this massive antitrust case. And in doing so, one of the parties urged the judge to depart from precedent. There was precedent in that jurisdiction for allowing the rather broad sweeping discovery sought by one of the parties, and for the imposition of sanctions for the other party not producing the discovery. And one of the issues in the case was whether the court should depart from precedent in that jurisdiction over the discovery issue. And the judge said, well, I'm not going to depart from precedent. He said precedent is very important, and it's a anchor of the jurisprudence system. And the judge said the reason not to in this case, at least not to depart from the precedent is because, quote, you're going to have to serve somebody sometime. And that's again from a Dylan song, Gotta Be a Troubadour. It's his 1979 song about you gotta serve somebody. The court used that as a motif for saying why precedent should be followed. We have to serve precedent. We have to serve the precedents of the past. Another Dylan decision, another case that involved Dylan lyrics was a New York civil court case. So this is New York State Civil Court. And this was a case in which an individual brought a class action claiming that he was charged a toll for purportedly driving his car over one of the New York toll bridges when he wasn't driving the car. He said there was a mistake here. The system mistakenly charged me when I wasn't driving a car. And he brought it as a class action on behalf of all of those purported people who were wrongfully charged tolls for occasions in which their cars were not actually going over the toll bridge. And the judge in the case, deciding whether to certify the class or not, cited a Dylan lyric from his 1964 song, It Ain't Me, Babe. And the judge cited that and said, well, he used that as an analogy. So what the claimant is claiming here is when he was cited, he was given a toll. He was cited for a traffic toll on a day he wasn't driving, and that he equated that with Dylan's song, It Ain't Me, Babe. He said the claimant is saying, I wasn't driving, quote, It Ain't Me, Babe, referring to the Dylan song. So these are just a few of the examples of some of the cases, some of the more than 200 cases in which Dylan has been quoted and cited by courts. All of these cases that I've addressed were cases that took place on the coast, both the West Coast, the California case, well, there's the two Supreme Court cases, the California cases, the Florida case, and the New York case. They're all on the East Coast and the West Coast. So it occurred to me, well, I ought to look up the Minnesota case law because certainly as a Minnesota resident, a Minnesota native, born in Duluth, raised in Hibbing, certainly the Minnesota case law would reflect some quotes and lyrics and citations and reliance on Dylan's lyrics. This is the number of cases I was able to find, and maybe someone can do me better and find some, but I did not find, at least in any reported Minnesota cases, any references or citations to Dylan lyrics. Maybe that's an oversight on my part, but more significantly, maybe it's an oversight on the part of the judiciary who hasn't resorted to relying on Dylan lyrics, even though so many other courts have. But Dylan's not alone. Is Dylan's not alone in being cited for in legal cases, as we'll see in the next slide. The Stones also managed to get into a lot of legal cases. One of them is a New York case, Colonial Credit Corp v. Byers. And this concerns unlawful practices in connection with debt collection lawsuits. Again, another debt collection case, just like the Chief Justice Roberts' rumination about the standing in that Supreme Court case. This was a case in which a number of multiple debt collection lawsuits were grouped together, claiming unlawful debt collection practices, and they were before a particular judge on the trial court bench in New York City. And the judge lamented about having all these cases grouped together, and grouping all of these debt collection cases together in one massive arrangement here, said is giving me a, quote, 19th nervous breakdown, unquote. And he said a judge who's in handling these cases, all collected together in different formats, requires a mother's little helper to alleviate the stress of litigation. Obviously, those are lyrics from one of the Stones songs, and the Stones were cited in that case by the judge. Another Stone citation is a workers' compensation case out of Kansas, Hill versus Kansas Development of, it should be Department, another typographical error by me, one of many. Hill versus Kansas Department of Labor. This is a very convoluted workers' compensation case, although really stripped to its essence. It essentially involved the exclusivity clause of the Kansas workers' compensation law, which is comparable to the law in Minnesota, and I suspect in most other states. The workers' compensation law generally, in Minnesota and in other jurisdictions, including Kansas, has an exclusivity provision, which, with some exceptions, provides that if a worker is injured in the workplace or related to the job, they have the right to claim workers' compensation, and that becomes without fault on their part. But that becomes an exclusive remedy, and they cannot pursue any other claims outside the workers' compensation realm. There are a number of exceptions to that. In some cases, a suit can be brought for intentional wrongdoing against a civil tort claim can be brought against an employer for intentional wrongdoing or knowing wrongdoing above and beyond the workers' compensation law. In some cases, claims can be brought against co-workers for injuries suffered that would be otherwise covered by workers' compensation. And of course, claims can be brought against third parties. Tort claims can be brought against third parties outside of for an injury that occurs on the job, but is caused by a third party. The most typical examples would be automobile accidents, where an individual is injured on duty while driving a vehicle, and they can sue the third party who allegedly committed the negligence. In some cases, product liability cases, if there's an injury in the workplace. But generally speaking, the workers' compensation exclusivity provision channels most workers' compensation claims into most work-related injury claims into workers' compensation. But there are alternative remedies available. That was the issue in this case, as to what kind of remedies an injured employee can tax together above and beyond the workers' compensation scheme. And the court in that case pointed out that you have to pick and choose which remedies you want. You can't always get every remedy that you want out of a single injury. And the court cited you can't always get what you want from the Stones song. It's a Stones lyric from one of their songs. And that has a kind of an interesting Minnesota backstory to it, um, which many of you are familiar with. The Stones back in 1962 were a virtually unheard of band. They hadn't broken through yet in 1962, and they were touring various spots in the Midwest. And one of their gigs was at the Excelsior Amusement Park. Some of you may remember the Excelsior Amusement Park. It stood where the old log near where the old log theater is, neither of which are operational now. But the Excelsior Amusement Park was sort of a vintage form of what later became the more massive amusement parks. But it had a little roller coaster and a little merry-go-round and other rides of the day, and it was fairly popular at the time. Um, and The Stones were playing out. They had a little uh, auditorium area there, outdoor auditorium area, and the Stones played there. I think there were 200 or 300 people who attended their concert, and the Stones had a weekend gig there at the Excelsior Amusement Park. As told by several people, including Mick Jagger. Mick Jagger has told this story. Jagger recounted this when he was here on one of the Stones. I think the Stones have been in Minnesota 7 times, maybe more. But in one of the occasions, about 5 years ago, when the Stones were here in Minnesota playing at the um, University of Minnesota Huntington Bank Stadium, uh, uh, Jagger mentioned this song. He says, "It's nice to be back in Minnesota." He said, "When we go back," he referred to Excelsior. He said, "We go back to Excelsior Park where we played some 60 years ago." And he told this story about that song lyrics were derived. The lyrics were derived for that song. You can't always get what you want. When one of the members of the band was ill and had a nasal infection and went to the local pharmacy in downtown Excelsior. That pharmacy still exists there, different ownership, but it's a pharmacy right in the old downtown of Excelsior. And they were looking for some particular cold remedy, and the pharmacy didn't have that particular cold remedy they were asking for, which they were familiar with from Britain. But he gave them a different cold remedy that we had here in the U.S., and they took that cold remedy instead rather than the one they asked for. And as they were walking, there was a customer there was a gentleman actually outside, and he heard them inside, and they were talking and a little bit complaining about how they couldn't get the medication they wanted. And the individual who was outside the pharmacy as they left said, "Well, guys, you can't always get what you want." And that phrase, and you can't always get what you want, so you ought to be satisfied with what you have. And the individual in the street in Excelsior mentioned that to the Stones was the derivation of their song and that song lyrics, which came into play in this Kansas workers' compensation case with the Minnesota derivation to it. The Beatles have also been relatively common um, sources for judicial decision, and there have been several references to Beatles songs by courts. One Judge Alito referred to the Beatles on 2 occasions. One of them when he was on the Third Circuit in a case called Marshak versus Treadwell. This was a dispute about who owns the right to the name of a band. It wasn't the Beatles were not the subject of the case, but they snuck in sideways to the cases I'll mention. But the issue was when a band breaks up, who owns the rights to use that band's name when there's a breakup and some of the members go off in one way and form a new band, and some of the members form a different band, and some of the members don't form a band at all, but have some rights maybe to the name of the band. Um, there are some states, California in particular, I think, that have laws about that. For instance, in California, the law was, and probably still is, that if you have one of these bands that is a derivation or a revival band of another band from a different era, you have to have at least 2 members of that band who are at least 2 people who are affiliated with that band to use the name. For instance, if you come back and use the name the Mamas and the Papas or the Beach Boys, you have to have at least 1 and perhaps 2 people who have some relationship to the band in order to use that name. I was at a Beach Boys concert, about 5 or 6 years ago, and it was purported the Beach Boys, and there was one of the original Beach Boys was in that concert, along with one of the other individuals that they introduced was the cousin of the sound man for the Beach Boys back in the 60s, and that sufficed to satisfy the California two-member law. So they were able to use the name Beach Boys. In this particular case, the issue is who gets the name of who has the trademark rights to the name of a disbanded band. And Judge on the Third Circuit, Judge Alito wrote the decision, and in his decision, he basically said that a group that disbands still owns the rights to that name. Now there's a dispute as to which particular individuals can use that, but the name itself is a property right that's owned by the members of the band, subject to whatever contractual rights they may have among themselves. And in that decision, Justice Alito referred to the history of the Beatles and the breakup of the Beatles, and he went back to the late 1960s when the Beatles broke up, and he said there were disputes then about who can use the name Beatles, but the Beatles can be protected as a matter of copyright, and even if it's not protected statutorily, it's a property right that can be protected contractually, and he referred to the Beatles breakup as in his reasoning in that case. Another occasion in which Judge Alito, now on the Supreme Court, referred to the Beatles came in 2009 in a case called Pleasant Grove City versus Summa. That case involved the placement of the Ten Commandments at a city park, an issue that's a recurring issue is the use of the Ten Commandments or the placement of the Ten Commandments on city or a government-owned property. The latest iteration of that issue is down in Texas and Louisiana, where the Fifth Circuit has, in two consolidated cases, upheld the Texas and Louisiana laws that recently passed that mandate the placement of the Ten Commandments in every, I think it's only elementary, but every elementary public school in those states. The laws are very similar. They're derived from the same basis, where the public schools are required to post the Ten Commandments in either all classrooms, or I think in one of the states it's only the elementary classroom. And one of those two states, Louisiana or Texas, imposes fines on teachers who don't comply with that law. It's been challenged, of course, on First Amendment grounds as establishment of religion, and there have been a bevy of other cases like that, parks and schools, and the courts have sort of split. The Supreme Court is somewhat split on those cases. In some cases, the courts have held that the Ten Commandments can be used and expenses paid and maintained by public funds in certain circumstances if they're considered historical in nature, and if they're placed in a setting that has other monuments with other inscriptions that are historical in nature. The courts have said if it's historical, it's permissible to use public funds on public property for the placement of the Ten Commandments. In other cases, the Supreme Court has said if it's not historical, but it's standalone, it can constitute an infringement of the First Amendment establishment clause. So it's kind of a wavy line there as to where and when the courts can impose the Ten Commandments can be placed. This case addressed that issue in the Pleasant Grove City case, and in doing so, the court referred to, Justice Alito wrote the decision. He referred to how it's customary and common in municipal parks to have plaques or monuments to particular individuals or particular people. And they ruled that in this case, it was permissible for the city to have the Ten Commandments in its park, and he analogized to other monuments in city parks, and he referenced a plaque honoring John Lennon, referring to his Imagine song that's in Central Park near the site of his 1980 murder. And Alito referenced that as an example of the permissibility of putting monuments or plaques in public parks. And he said, well, if you can do it for Lennon, you ought to be able to do it for the Ten Commandments. There's another New York related case decided by the Second Circuit that involved the issue of setting aside a public schoolroom for after-school meetings of religious students. This is in a public high school where the school board set aside a room for students in the school to conduct religious, not religious services, but to conduct a religious faith meeting of students wishing to do so. It wasn't mandatory, it was voluntary, but the school board and the school gave them a room to conduct their religious meeting after school hours. The issue was whether that was a violation of the Establishment Clause of the First Amendment. And there have been a number of these kind of cases too concerning set-asides for religious purposes in public schools. And the court, the Second Circuit ruled that there was a violation of the First Amendment. It was an Establishment Clause violation because students were allowed to set up a religious facility or be allowed to use a public facility for religious purposes and to engage in worship if they wished. They could, but they didn't have to. A dissenting judge said, well, this is a little bit too broad. He said the term worship can cover a lot of different issues. The school board's policy was to allow students to engage in worship. That was interpreted to mean religious worship, and therefore the court said religious worship is impermissible in a public property. The dissenting judge says, well, the term worship can mean a lot of different things. It doesn't necessarily mean only religious worship. And the judge said we should construe this to mean any kind of worship. And he said worship can be, quote, as simple as reverence for something like the Beatles. And because the term worship can be so broadly construed to include worshiping the Beatles, the majority went too far in striking down the policy against worship in public schools. Next slide, please. More Beatles here at the bar, more Beatles. And the Beatles, as I said, are managed to find their way into a number of different cases, not as often as Dylan, but about on par with the Rolling Stones. I think it's about 100 times each. Both of them combined equal about the number of times Dylan's been cited. This is a case in which the Petrick versus NCY Musical World involved a concert in Chicago, and a fan sued. This was another class action suit. A fan sued for a refund because he was not able to attend this concert in Chicago because of the traffic and parking problems that he had. The concert was conducted at, I think it was conducted at one of the baseball fields in Chicago, and the fan couldn't get in because of the traffic and parking problems. A number of fans couldn't get in, so a class action was brought seeking refunds because they were not able to attend the event due to the traffic, couldn't get into the event due to the parking and traffic problems. And the court equated that to an incident that happened back in the 60s when the Beatles played at Wrigley Field. The court said, well, that's going to happen back in 1965 when the Beatles were in Chicago. And when the Beatles played at Wrigley Field, there were similar problems with traffic and parking, but nobody brought any lawsuits back then. So you shouldn't be able to, why should you be able to bring a lawsuit then? And now, and the court in that case referenced when the Beatles played at Wrigley Field in Chicago. Incidentally, that was wrong. When the Beatles played in Chicago, they only played there once. The Beatles played at Comiskey Park, which was the then home of the Chicago White Sox. But the court referenced Wrigley Field, which of course is where the Cubs play. So the court made an error in that respect, but the reasoning was applicable nonetheless. As many of you recall, the Beatles played once in Minnesota, only once. They appeared here once, and that was at the old Met Stadium, where the Mall of America now sits. The Beatles played in August 20th of 1965 at Met Stadium. I was there, I was working there. And the Beatles, is reported to be the smallest Beatle crowd. That was the Beatles' first U.S. tour. They made another one the next year, but the first U.S. tour was in 1965. The Met Center was one of the sites. And that reported the attendance at at the Mets Stadium. Some of you may have been there. If you are, maybe you want to note that in the chat room here because you're always everybody else is noting the mistakes I'm making. Maybe you can note if you were at the game at the concert. But it was at Mets Stadium, out in Bloomington, where the Twins played and the Vikings for that matter. And the crowd was 29,000. The stadium back then seated around 40,000. So it was about two-thirds, three-fourths full, but that was the smallest Beatles crowd on that American tour. It also was, by most accounts, including mine, a pretty miserable event in many respects. As I said, I was working here as an usher, but I recall very vividly the Beatles came out, and some of you may remember this. Some of you may have been there in 1965. It's only 61 years ago. There was a couple of opening acts, forgettable opening acts. And then the Beatles came running out of the dugout. I believe they came out of the first base dugout. Um, and the stage was set up where second base is, between the pitcher's mound and second base on the Met Stadium baseball field. And of course, there weren't seats on the field itself. The seating was in the grandstand. So nobody was seated on the baseball field itself. The closest people were in the grandstand and their view was from the grandstand 50 or 60 feet behind home plate out to near second base. So the view was the visuals were very diminutive. Um, and the sound system was pretty bad, even by 1960 standards. You couldn't hear much at all. And what you could hear was fans screaming, and they were screaming at the Beatles, but they probably maybe have been screaming at the ticket prices that they had paid because you couldn't hear very much and you couldn't see very much. And the tickets went at top dollar at $5. Those were the top dollar tickets were $5 at that time. Um, the Beatles played 11 songs, did 11 songs, and uh, the show their performance was timed at 31 minutes, so it was a little over a half hour performance, 11 songs. And they thanked everybody sort of and ran back to the dugout and they were gone. That was it. They were in here one day only. Um, and The lore is that back at the hotel, there was an incident. They stayed overnight at the hotel. I don't know which one. It was in downtown Minneapolis. And the lore was that there were a lot of young girls hanging around at the hotel. This isn't even lore. It was reported at the time. And the local police had to go into the rooms of some of the Beatles and remove some of the young ladies that managed to, were brought in or came in or were invited into their rooms that night after the performance. But no charges were brought against anyone for that. And that was the saga of the Beatles in Minnesota. And I use that because one of these cases talked about the Beatles playing at Wrigley Field in Chicago. A couple of other Beatles related cases were addressed. Were addressed. One's a complex bankruptcy case out of the Ninth Circuit in Ray Smith. And this was another one of these complex cases in which the court refers to and analyzes the case. They went through counting the fact pattern of the case, which was very complex, and it went up and down through the court system and finally in the bankruptcy court. And the bankruptcy court analogized how that case had proceeded through the legal system as a, quote, long and winding road, citing a Beatles song. The same, quote, long and winding road, unquote, Beatles analogy was used in another case in Rhode Island, Cohn versus Larson. This case involved a dispute over the use of an automated billboard. Automated billboard. Some states ban those automated billboards, and I think there have been some laws in Minnesota, either state laws or local ordinances that have prohibited the automated billboards that change automatically on grounds that they are a distraction to drivers. This case involved a similar issue about the use of an automated billboard on the road in Kansas. I'm sorry, on road in Rhode Island, and the court referred to the, quote, long and winding road analogy of the Beatles in its decision in that particular case. All right. So that's kind of an overview of some of the cases, focusing on Dylan because it's 85th birthday, but also leading into some of these other cases decided by courts in which the Stones and the Beatles have been cited. And as I said, there's other popular musicians have been cited frequently too, although not nearly as frequently as the trio of Dylan, Stones, and Beatles. But Springsteen, Simon and Garfunkel, and others have made it into some of the cases as well. Um, uh, I've cited a couple of Simon and Garfunkel lyrics in a couple of my briefs, but they didn't make it into the published decisions. And as I said, there are, to my knowledge, no published decisions in Minnesota citing Dylan, at least. So that's where we are, folks. So we'll go to the next slide. Can we go to the next slide? That's all, folks, but not quite, right? Next slide, please. We have a quiz. Okay. Since we got to get CLE credits here, we have to put people's brains to work here. All right. All right. You can just answer these yourself and grade yourself. Dylan performed near the University of Minnesota where? Which one of these four spots was where Dylan performed during his short tenure as a student at the University of Minnesota? The Campus Club, the New Minneapolis Cafe, the Gopher Hole, or the 10 o'clock Scholar? Anyone want to guess there? All right. Well, it's D. Right? Who played the Twin Cities character who played Dylan? He's not a Twin Cities character. The character who played Dylan from the Twin Cities. I'm sorry. The character who played Dylan in the movie A Complete Unknown um, was also played Marty Supreme in a movie last year. Another highly regarded movie, Marty Supreme. That's Timothy Chalamet. We talked about him earlier. Um, in the movie Marty Supreme, this was the actor who played Dylan in the movie. What was the role that the Timothy Chalamet, the Dylan actor, played in Marty Supreme? Many of you may have seen that movie. It's fairly recent. Poker player, crypto trader, ping pong player, evangelist.
We got a couple people posted in chat. They got the right answer, I believe.
Okay, well, what's the right answer, Shannon?
C.
Yeah, ping pong player. All right. Who was one of Dylan's early mentors? Willie Nelson, Pete Seeger, Woody Guthrie, or Arlo Guthrie? Everybody. Yeah, see, that's an easy. No, I'm sorry, you said Seymour. Oh, I'm sorry. Someone says to everybody. I read that wrong in the camera. All right, well, A, B, C, or D? The answer, Shannon, is
It looks like we've got a mix. We've got a B for one or two people and C.
it's B.
It's B.
B. All right, next slide, please.
All right, let's
This
go.
is fun, isn't it? You don't get
Yeah.
this in all your
Oh,
CLEs. You
absolutely.
don't get this in all your CLEs. You see, I love the Ramsey County Law Library CLE. Shannon does such a good job in her eclectic CLEs. All right. All right. Dylan's parents, Hibbing, owned what? Tobacco store, diner, carpet cleaning, appliance store. Which one is it? You got it, Joan. It's actually, that's a little bit of a misnomer. D is the right answer. It's an appliance store with hardware. It's kind of a combined appliance and hardware store. And for Hibbing, it was their version of the Mall of America.
Hmm.
They had everything there. All right. Dylan from Hibbing, we've already covered that about 3 times here, but who isn't from Hibbing? Here's 4 well-known people. Which one's not from Hibbing? Singer Gary Puckett of the Union Gap. Forgot the name of his famous song, but Gary Puckett, the Union Gap.
A lot of people are
Basketball.
guessing Nanny, Lou Nanny.
Yeah, Lou Nanny. Of course. Hockey. How could he not be from Hibbing, right? Lou Nanny from the Sault Ste. Marie, Lou from the Sioux. But all these other 3 were from Hibbing. Singer Gary Puckett of the Union Gap. Basketball's Kevin McHale. McHale was known to say, he said, growing up, I was the only kid in Hibbing who didn't play hockey. At 6'11", he probably could have been a fairly decent goalie. Charles Manson, prosecutor. Vincent Bugliosi, he prosecuted the Manson case. And after that became a kind of a well-known author and raconteur and celebrity guest of sorts, and wrote a number of other books. He also wrote one book about the Warren Report. He was a Warren Report supporter. And he wrote a pretty interesting book supporting the Warren Commission against its various critics. Warren Report against his various critics. He also did a pretty interesting book about the OJ case in which he analyzed the OJ case and the evidence and concluded, surprisingly, that OJ was very guilty. Bugliosi was from Hibbing, and he was the 1951 state high school tennis tournament champion. And that was the days when they only had a class A. There was just one class. There wasn't this class A, B, C, D, E, E, and all that. It wasn't five or six classes. I guess for tennis they only have two classes, but for basketball and football I guess they have six classes. But he was the best high school tennis player in the state of Minnesota, coming from that renowned hotbed of tennis, Hibbing. Last question. At the Nobel Prize ceremony, Dylan did get a Nobel Prize in 2016. What did he do? A. Thanked the Lord for his success. B. Sang two songs. C. Gave a rambling speech. D. Did not show up. It
It
could have been any.
looks like D. Everyone's voting for D.
Yeah, well, that's kind of an easy one. It could have been all of those, though, I think. The other three were made up out of my fertile mind, but if I went to put D in there, it would have been interesting to see how many people vote for A, B, or C, because they kind of sound like what he might have done. But it's D. And that is the conclusion of my presentation. We have about 5 minutes left for maybe comments or questions. I think we have a lot of comments in the chat room. Probably most of them are pointing out errors I made in citing some of the songs. But anyway, I'll take some questions or comments, or if you want. I hope you enjoy this. It's kind of a fun exercise, a little bit offbeat, but it does. I think we should qualify for a CLE credit for this, Shannon, because there is a significant law involved in this, but it's law in a way that integrates pop culture or pop music with law, and talking about how the law has been affected by some of Dylan's work, and maybe how the law has affected some of Dylan's work as well. So
Yeah, no,
hope
I absolutely agree with you. I think it's great to have something different, and I loved, bringing in the CLE this afternoon with a little bit of background Dylan music. Hopefully, people were able to hear that. I wasn't sure if it came through, but that was part of the lead in for the CLE today. I'm looking through the questions. Looks like people mostly comments. Well done. Thank you. That was fun. Here's one. Don't forget, as Dylan saying, to live outside the law, you must be honest.
you're right. That's true.
That's
Good point.
a good maybe a good note to end on. Here, I've got a couple people asking for the code again. And just so you're all aware, I do send out, if you're on the attendance list, if you've entered in your email address, I do send out the materials that are here up for you on the screen, as well as the CLE event code number. I did check it this morning. It had not been approved yet, which I was kind of surprised by because it's been in there for a while, but sometimes, summertime it gets the approval rate can be a little bit less than what I would expect in during the regular I guess year. So
Well,
let's see.
thank you for Shannon for inviting me to give this presentation. I hope people enjoyed it, and I perhaps will see some folks again as Shannon said, October. I participate with co-presenter David Schultz, generally of Supreme Court review, and we usually do that in October. And it'll be interesting to see if there's any Dylan lyrics cited in any of the Supreme Court decisions during this current term.
Yeah, we got a couple. Yeah, thank you. It was fun and interesting. And then one person asked about registration for the next CLE. If you go to the Ramsey County Law Library webpage, just Google Ramsey County Law Library, you should pull up the website, and it's usually posted right there. Right now, it's obviously this one. I usually takes me a couple days to get the next one posted up there, but essentially you can register for the next one as soon as that posting goes up, and should be up, maybe halfway through the month. Thank you everyone for attending, and thank you, Marshall. Appreciate it as always. Uh, here's one question. I guess this is kind of an interesting one. Are you a Dylan fan, obviously, or what inspired the CLE?
Well, I'm not a Dylan groupie. I like Dylan. I've attended, I think, two Dylan concerts in the day. I'm not a Dylan groupie. But what did inspire it is actually it goes back a few years ago when the one of the Stones tours here to Minnesota. I was wondering if their lyrics had been quoted in any songs, and I did a piece on the Stones songs. And it was a longer piece than this, just about the Stones. But then as Dylan's 85th birthday approached, I said, "Gee, I wonder if Dylan's been quoted. The Stones have." And then I did a little bit of research and found out that Dylan's been quoted so many times. And there's a couple of law review articles that go into great depth about citing all of the song, not all, but most of the many, I should say, of the top musical performers who have been cited in various court cases. So this is derived in part from that, and in part from my own research, such as it is, and also from my painstaking review of Minnesota case law to try to find one single Dylan case, and I couldn't. So there's the challenge for our listeners and viewers.
Yeah, that is interesting that he's been quoted in
Yeah,
other
yeah.
places, other courts, but never in Minnesota.
And I know a lot of lawyers, I mean, not a lot, but not lawyers from time to time will cite, lyrics from popular songs in their briefs and argumentation. I know there's a number of judges who are attending here today, and maybe this is just a little hint that if they have a chance, they can weave in some Dylan or other lyrics into one of their uh, uh, esteemed legal opinions.
There you go. He's thrown it out the challenge. So, well, thank you all again for attending, and we'll see you next month. Take care, everyone.